The month of August witnessed some really important rulings and orders from the Supreme Court. Let me quickly list down the unmissable stories for you. Justice NV Ramana retired on August 26 after serving as the 48th Chief Justice of India for about 1.5 years. He has delivered about 280 judgments in his 8.5 years at the Supreme Court. Justice Ramana, who comes from an agricultural family of a small village in Andhra Pradesh, mentioned in his retirement speech that he first saw electricity at the age of 12. Isn't it commendable that a first-generation lawyer from a humble background went on to hold the highest judicial office in India? In a very progressive verdict, the Supreme Court has held that the term family includes domestic or unmarried partnerships and even queer relationships, and hence child care or maternity leave benefits cannot be denied if women do not fit into the popular imagination of a family. Sections 3 and 5 of the 1988 Benami Property law have been held to be stillborn and unconstitutional. Consequently, the 2016 amendment was held to apply prospectively. Supreme Court dismissed the plea on sanction to prosecute UP CM Yogi Adityanath in a hate speech case that led to the 2007 Gorakhpur riots after noting that a closure report has already been filed in the case. After the inquiry committee headed by Justice Indu Malhotra, former judge of the Supreme Court of India, submitted the report on the alleged breach of security that left Prime Minister Narendra Modi stuck on a highway in Punjab for 20 minutes on January 5th, the Supreme Court has sent the report to the central and state governments for appropriate action against the delinquent officer. Notice has been issued to Gujarat government after Bilkis Bano's rapists walked out of the prison on August 15 after serving 15 years in prison based on Gujarat government's remission policy. In a public statement, Bilkis Bano wrote that the release of a rapist has left her bereft of words and numb. For the uninitiated, Bilkis Bano was 21 years old and 5 months pregnant when she was gang raped. She saw 14 of her family members being killed, including her 3-year-old daughter, in the 2002 Gujarat riots that broke out after the Godhra train burning. The Insolvency and Bankruptcy Code 2016 would prevail over the Customs Act 1962 to the extent that once moratorium is imposed in terms of sections 14 or 35 clause 5 of IBC, as the case may be, the Central Board of Indirect Taxes and Customs only has a limited jurisdiction to assess or determine the quantum of customs duty and other levies, as it does not have the power to initiate recovery of dues by means of sale or confiscation as provided under the Customs Act. Supreme Court has held that arbitrators do not have the power to unilaterally issue binding and enforceable orders determining their own fees. While Justice D.Y. Chandrachud wrote the majority opinion for Justice Suryakant and himself, Justice Sanjeev Khanna wrote a separate opinion where he agreed with the majority opinion of certain parts but disagreed on the point that in the absence of any agreement between the parties or the parties and the arbitral tribunal or a court order fixing the fee, the arbitral tribunal is not entitled to fix the fee. CJI NV Ramana-led 3-judge bench has called upon a 5-judge constitution bench to decide the issue relating to interpretation of Schedule 10 of the Constitution vis-a-vis disqualification, Speaker or Governor's powers, and judicial review. In the issue relating to promise of freebies by political parties before elections, the court has observed that the issue requires extensive debate as such promises may push the state towards bankruptcy. A 3-judge bench will now hear this matter.